All right, everyone, thank you so much for joining us today. We have our guest speaker, Miss Ashley Naramore, but I'm going to introduce Laura. She is a financial advisor here at Aspire Wealth Builders, and she is going to do the introduction of Miss Ashley. So here is Laura.
Hi, thank you guys so much for joining us. It is my pleasure to introduce Miss Ashley Naramore. She is a Hot Springs native, focusing her practice on estate planning, probate, wills, trust, guardianships, and business formation. After graduating valedictorian from Lakeside High School, she attended the University of Arkansas. She earned her BA in psychology in 2005 and her JD Law degree in 2008 from the University of Arkansas, where she also graduated with high honors. She began her legal career in Little Rock, where she served as a law clerk for 2 circuit judges before finding a professional calling in the estate planning area of law. She pursued a master's in elder law and estate planning and earned her LLM from Western New England University School of Law in 2012. Ashley and her husband then decided to return home to their roots in 2011, and then Ashley joined the Bain Law Firm as an associate attorney. In 2015, Ashley and Karen Bain Riegler founded Bain Riegler and Naramore PLLC. Ashley is also a member of multiple professional and civic organizations and was selected through the Hot Springs Sentinel Record Reader's Choice Awards as one of the best attorneys in Hot Springs for 4 years in a row. She enjoys sharing her passion for the law and speaking about estate planning topics to groups of all sizes. When she's not working, she shifts her focus to family and enjoys adventures with her husband and young children. She enjoys participating in community events, calling the hogs, and spending time on the lake. So, Ashley, thank you so much for joining us.
Thank you so much for that introduction, Laura, and thank you, Laura and John and Caitlin, for asking me to speak today. Like Laura said, I am an estate planning attorney, and I always enjoy the opportunity to visit with groups and individuals about something that I'm very passionate about. It gives me great joy to be able to help my clients and help bring them peace of mind. Today I was kind of focusing on estate planning geared towards what every woman should know. However, estate planning is so important for everybody. Women do have some considerations that are a little different than men and make it even more important, in my opinion, to have a good estate plan. A carefully considered estate plan allows you to determine how your property is distributed when you pass away, and it allows you to designate someone to help you make decisions and make sure that your needs are met if you become ill or incapacitated during your life. Again, while it's the same for men and women, unique considerations do affect how women should approach their estate planning, because 90% of all women will be making financial decisions on their own someday due to being widowed, divorced, or unmarried. Other things that tend to affect women differently are that women's income is lower than men's. Women on average work fewer years than men due to family, priorities, being out on maternity leave, having children, caring for elderly parents, and statistically speaking, women outlive men. So it is very important for everybody to have a good grasp on your financial situation, but very likely women may end up living longer and be the ones who end up having more issues to deal with. So, first things first is, what is estate planning and why is it important? And estate planning, a properly designed and executed plan, allows you to select trusted individuals to act on your behalf, both during life and after you pass away. And it ensures that your wishes are met. And if you do not have a plan, and I know that it's a hard thing to think about, and it's not a fun and exciting thing to think about, but I have seen so many times in my practice what happens when when people don't think about these things ahead of time, and when you don't, the state will decide for you. Each state has statutes that determines what happens to your property or who could make decisions for you. And so if you plan ahead of time, you get to be the one controlling those decisions, not the state of Arkansas. Now, as far as where to start, if you have never given consideration to estate planning, or even if you already do have an estate plan, the first step is to inventory your assets and make sure that you have a detailed inventory of all of your property and kind of a rough estimate of its value. And if you go to an estate planning attorney, he or she will need to have an idea of what kinds of property you do own, how you own it, and kind of a rough value to know if we need to think about tax considerations and kind of the direction to go in as far as planning. It's very important to have this inventory, especially if you became incapacitated, because bills need to be paid. We can't let the insurance lapse on the house or the vehicles. And it's really hard, especially in the digital age where many individuals do not receive paper bank statements, for instance. If everything's electronic and you don't have any kind of, printout showing that, it's very difficult for someone else to find that. So educating yourself as to your finances, even if you're not the one handling day-to-day financial decisions, make sure that you are educated. And the next step is, talking about what estate planning documents that everyone needs. Everyone needs an estate plan, regardless of the size of your estate. And there are several planning tools that we can use as estate planners, but I do want to emphasize here that estate planning is so much more than the documents. The documents are the end product, but getting there is the most important part. And yes, anyone can go onto LegalZoom.com and pop out a will that probably would meet the state's formalities. But I frequently see with do-it-yourself estate plans, what I refer to that, is that the documents don't actually achieve the objectives that the client's wanting to achieve. So a lot of what I do, while I do a lot of writing and drafting of documents, the most important work is helping my clients turn their goals into a finished product. And being able to know what kinds of questions to ask, what things to look for, and help counseling my clients on how to make decisions, because a lot of these things are not things we've given a lot of thought to. Well, I'm trying to, if someone's trying to pick a person to make medical decisions, what kind of factors do we want to think about, and how do we come to determining, who you want that person to be. So there's kind of two sides to estate planning. The first is planning for incapacity. The second is planning for after you pass away. So for incapacity, if you do not have documents giving someone else the legal authority to make decisions for you medically or financially, and you become ill or incapacitated, the only way someone else can make those decisions for you would be going to court and getting a guardianship, which is actually a living probate. And that is a long and cumbersome, often expensive proceedings, and they frequently end up with family members arguing and other disputes because you're dealing with sensitive situations. So if you have a power of attorney for healthcare, you would designate someone else to make or communicate your wishes to your medical professionals in the event you're unable to do so. You also need to have a financial power of attorney, and that is a document allowing another person to step in your shoes to carry out legal tasks or transactions on your behalf. It would let someone sign a legal document access funds in a bank account, talk to the IRS, have your tax returns prepared, sell property. And this document can be customized, it can be limited, or it can be very broad. And that is something that we always want to discuss and trying to decide how limited or how broad. It can be effective immediately on signing, or it can be effective only upon incapacity as certified by a medical professional. So those are some of the things you want to think about when trying to determine who you would put as an agent, which is what we call the person we're giving authority to act under the power of attorney, what kinds of authority we want to give them. And we always want to make sure that this is someone that is trusted, that is financially responsible, that makes good decisions, and who will manage your money and your finances in the way or manner that you would. Also, lifetime documents, a couple other medical documents that are important, a HIPAA release that allows your medical providers to share information with the authorized recipients that you put on the release. And then if you want to express wishes regarding life support or the lack thereof in the event that you were permanently unconscious at the very end of your life, then that is very important as well. In those decisions, if that does reflect your wishes, it's really important to have the legal document, because those are the hardest decisions anyone could ever have to make for you, and giving your family the assurance that they are following your wishes is really priceless. As far as documents in a plan to address your assets and what happens when you pass away, and the most frequent question that I get is how do I avoid probate? Probate is the process of proving a will and having a court declare that a will is your last will and testament, and that it is valid, and that it was properly executed without any undue influence under the laws of Arkansas. And when we talk about probate and does my estate have to go through probate, it's really looking at each asset you own. So it's a little easier for me to say what does not go through probate, or what does go through probate is an asset. And when I say asset, that could be a bank account, a piece of property, a life insurance policy, an IRA. So an asset owned individually without a beneficiary. So any asset jointly owned would be the property of the joint owner on the first owner's death. Any property with a beneficiary would go to that beneficiary by operation of law, would not have to go through probate. It wouldn't have to get unfrozen in probate. And any property held in a trust also avoids probate. And so as far as what is the best plan for you depends on a lot of factors. Most importantly, your family situation, your children, who you want to benefit, if you want to designate how and when they can receive funds. And there are a lot of considerations that come into play when deciding the best way to pick that up. Even if you have a will or a trust, we still have a will, and that is called a pour-over will. Just in case a piece of property did not get placed in the trust. And so a trust is a very frequent tool used to manage property and distribute it upon death. And in a trust, you name a person called a trustee to manage money. If it's a revocable trust, you are the creator of the trust. It's called the grantor. And the grantor is also the beneficiary, typically during lifetime. And then on death, you name a successor trustee to carry out your wishes. The nice thing about trust is that they give us a lot of flexibility to take into account lots of different potential scenarios. Because it's hard to, we can only plan with the facts that we have at the time. But we can build in some flexibility so that if unanticipated things do happen in our lives, we can still make sure that our testamentary intent is carried out. And when I say testamentary, I mean our intent of what happens to our property on death. So again, trusts give us lots of options. We can plan for beneficiaries with special needs. If someone's receiving government benefits, Medicaid, Social Security, plan to make sure that they don't lose their benefits. We can plan for beneficiaries who have financial problems, marital problems, substance abuse problems. And we can, make your money and your legacy last longer. So these are just kind of a few things. And again, my goal today is just to give some basic information and kind of things to think about. Obviously, it's more than we can cover in 20 minutes on all the details, but just to kind of get your wheels spinning and things that you want to think about when you start thinking about estate planning. Once you have an estate plan, or if you already have an estate plan, we want to make sure that that estate plan is properly maintained. And what I mean by that is that we review the plan every few years to make sure that it still accomplishes our goals, that laws have not changed that need to be updated. Tax laws change frequently, and plans may need to be updated to take into consideration tax laws. I will say one thing that I see a lot of are trusts from the early 2000s are laws regarding estate taxes were vastly different. And a lot of these older trusts accomplished a very good objective then, but they really are not appropriate for now and end up having some unintended consequences that we could have avoided had we revisited. Another very important thing is to make sure that you actually know where your documents are located. It is all the time. I have clients that, oh yeah, I have a will. And then we'll talk about, well, where is it? Oh, well, I don't know where it is. So it is very important to make sure that you have easy access to the documents and that have the documents, and that you update anytime, your family situation changes. It's very often, for young parents to set up an estate plan to take into account minor children and getting them to adulthood, making sure milestones are met. And then they don't update until the children are adults and graduated college, and the original plan may no longer be necessary or applicable. Of course, as adults, children have different needs to consider, such as are the children married, and then do we have blended family considerations? Do we have any creditor issues? So as we go through life, the various stages of life, the things that need to be considered do shift some. So again, just making sure that, if you've moved to a new state, always good to visit with an estate planning attorney and make sure that all of the documents are still effective, and that they will still accomplish your goals. Anytime if you get married, divorced, on retirement, it's good for us to look at these. If you've purchased property, or had other changes in your career, it's always a good time to review those. So with that, I will open the floor to any questions.
Ashley, this is John Herfel. I have, while you were going through your presentation, I wrote down a number of folks that came to mind that need to come and see you. But when I set up for this program that you're doing for us today, you brought up some type of a review process. What do you consider to be an older trust? Is it by date, or is it by event, or so has anything changed in the last 4 or 5 years that people who did do a trust may need to have it reviewed?
Yes, there have been some very significant changes in mostly with regard to taxes. In 2017, the estate tax exemption, and what I mean is the federal government says Arkansas has no estate tax. Okay, and the IRS says as of now, an individual can seven indexed every year for inflation can pass it's approximately $11.7 million combined during their life or on death without the money being subject to an estate tax. Prior to 2017, that number was 5.5 million. So, and then prior to that, even in the early 2000s, it was at one point it was 350,000 in the late 90s, and it was much lower. So what we've seen from an estate planning perspective, and without getting too technical in some of the various kinds of trusts we can set up to help minimize estate taxes and maximize those exemptions, planning strategies are very different, where you had a lot of people that fell into the taxable range with, when it was $1 million. We do not have a lot of people now who have more than almost $12 million, and for a couple that would be doubled to 24 million. So in many situations we can simplify a trust. One other important change was passed in January of 2020, called the Secure Act. And John, I'm sure you can tell me the acronym for it, but all caps, an acronym. And it, as far as estate planning goes, it affected planning for individual retirement accounts. And many of these trusts that we had set up so that we could stretch it out over an individual's lifetime who inherited that IRA, now we can only, except for certain exceptions, stretch that out over 10 years for a non-spouse. So if you had, say, a child or someone with credit or other problems, and we were able to stretch it out, say, over 40 years, we're not looking at having to distribute that much money. But if we shorten that to 10, we're talking about much larger distributions that might not be appropriate for the circumstances. So that's another thing that we would want to review.
So Ashley, also along those same lines, when Laura and I do good for clients, their IRAs increase, and they go maybe to their children or grandchildren instead of to their spouse because their spouse is no longer around. Mm-hmm. It's real easy for an estate to get inflated, especially if there's some life insurance. Even though the life insurance proceeds, say $700,000, might be tax-free, it still gets thrown into the estate, correct?
That's correct, yes. Yeah, the total estate would include, now unless we had a specific type of trust set up that is designed solely to hold life insurance and get it out of the estate, meaning where it is not included in that total value. But unless we have that, which we don't use a lot of anymore, then yes, life insurance proceeds would be included in that value.
I'll open it up to any other questions at this point.
I don't think we have any more questions at the moment. I just want to say, Ashley, thank you so much for taking time out of your busy schedule to do this webinar for us today. We really appreciate all the information that you've given us, and it was very beneficial. I have 2 small children myself, and so my husband and I have talked about an estate plan and a will and a trust, and getting everything in order in the event that something does happen. So I may be
I will mention, Caitlin, I'll throw in that for parents of young children or children under the age of 18, if something did happen, that child would need a guardian. And in a will, you can designate who you would want to be that child's guardian. And, it makes sure that they get that they would be with the person that you determine most appropriate, and it also helps take out any room for conflict or question as far as, you know, the most appropriate person. So that is one thing that we always take into consideration for anyone who had children under the age of 18. So
Fantastic. I will definitely make note of that. Thank you so much.
you're welcome.
And again, thank you so much for taking time out of your day. I know you're busy, and we just really appreciate you doing this for us.
It was a pleasure.
I'll be
Thank
happy
you
to
so-
follow up with you, Ashley, in the next week or two, okay?
Okay, sounds great.
All right.
Bye-bye.
Thank you. Bye-bye.